senior advocate and Rajya Sabha MP Kapil Sibal has slammed the Supreme Court in-house inquiry against Justice Varma, saying that the 3-member inquiry committee, which indicted the judges without hearing him and without following any due procedure. Joining us, Ashwani Kumar, former Law Minister during UPA regime. We want to know from Kumar how he will react on this Kapil Sibal argument. Sir, I just want to know what is your reaction? You have written a wonderful article in one of the newspaper. Now Congress party is saying, without hearing Justice Varma, how can you indict in inquiry?
I think that's not quite an accurate statement to make. Justice Varma was in fact heard. In fact, he was given an opportunity to put his case to the Chief Justice of Delhi High Court, which was then forwarded to the Chief Justice of India. It is not as if his view was not taken into consideration. His view was taken into consideration, and he had said that he had nothing to do with the cash that was found at his residence, and that it was found at a place where several other people also had access, and there was nothing to link the recovery of cash at his residence to him. To that extent, there has been no conclusive finding of fact. In fact, the inquiry committee constituted by the Supreme Court had no means to come to a conclusive and determined finding of fact that the money received was linked to the conduct of judicial functions by Justice Varma. So to that extent, it is right to say that the full opportunity of establishing his innocence has not been given to Justice Varma. In fact, I would like to say that in criminal law, the responsibility for establishing guilt is on the prosecution. It is not on the accused. It is for the prosecuting agencies to establish beyond doubt that the money was linked to the judicial functioning of the judge, which is not the case here. That has not been established. And therefore, to impeach the judge merely on the basis of a prima facie view taken by the committee appointed by the Chief Justice of India may not be entirely fair. And please remember, the point I'm now trying to make is an important point, namely that the graver the punishment, the graver the punitive consequences upon a person, the larger leeway should be given to that person to prove or establish his innocence, which has not been done in this case.
And you were articulating if anybody had placed cash in his backyard, in his outhouse, so without proper inquiry or police inquiry, how can you indict a sitting High Court judge?
Yes, that is true. So therefore, grave as the situation seems, unfortunate as the event is, the fact remains that the processes of fair trial and the due process of law has not been observed in this case. And that is the grievance of many people who are lawyers and who understand how the criminal cases are to be established. So the idea of the inquiry committee was that no judge should be unnecessarily maligned. In this case, the reverse has happened. The judge has been maligned. So many inferences are being drawn against the judge, whereas the judge has had no effective opportunity, as known to law, to defend himself.
And Mr. Sibal has said he is a wonderful, very wonderful judge, and whoever argued before him found that he is a brilliant judge. Have you argued before Justice Yadav? Do you know personally?
No, I have not had the pleasure of arguing before the concerned judge, but I hear that he enjoys a very good reputation as a judge. And therefore, I can safely say that I have not, before this unfortunate happening, heard anything against the integrity of the judge.
And many congressmen or Congress leader are pointing out that the handling of this case, Justice Verma case, is particularly to throttle the judiciary. Wherever in Justice Yadav case, where impeachment is the notice has been given, but chairman has not acted on his case.
Well, I don't know whether there's any conspiracy to subdue or silence judiciary or not. This is an inferential deduction by some people, and I'm not in the habit of just making inferential deductions. But yes, it does appear that two different standards have been applied in the case of Yadav and in the case of Justice Verma. I believe that since 50 MPs have given an impeachment notice, some decision one way or the other should have been announced by now. But that is now within the realm of the chairman of the Rajya Sabha, who is himself a distinguished lawyer and will take an appropriate decision. But as far as Justice Verma's case is concerned, I think the judge now has no option except either to face the impeachment proceedings, in which case, in all likelihood, he will be impeached, because that is how the political forces are arrayed in parliament. Or, in my view, the better course for the judge, for himself and for the institution, would be that he tenders his resignation. The judge may take a view that he is being hounded for no established culpability or no established guilt, and he's entitled to take that view. It is unfortunate that such a grave punishment is being meted out to a judge who has otherwise had an unsullied record without a definitive finding of guilt through the procedures known to law. And there cannot be a presumption of culpability in criminal law. The culpability and the guilt have to be proved beyond doubt. It cannot be presumed. That seems to have been the case with the report that the Chief Justice of India then had sent to the President.
You left Congress, but you are making a similar argument Kapil Sibal has made or Abhishek Manu Singhvi made.
Just because I have left the Congress party does not mean that I have to disagree with everything that they say. In fact, I agree with most of the things that they say. That is another point. By leaving the Congress party does not mean that I change my views. I have to retain my own intellectual and professional integrity when speaking on issues of public importance.
And I just want to know in earlier impeachment cases, like Kapil Sibal has said, in earlier impeachment cases, there was a substantial fact or evidence against those judges. But in this case, Justice Verma case, there is no substantial evidence, only acted on assumption.
Well, I'm not going to get into a comparative analysis of the evidence of those cases. I don't know which cases A or B is talking about. And I don't think we are discussing any particular law in our interview. We are discussing the issue of impeachment. So don't ask me to comment on what A, B, or C has said. The fact of the matter is that Justice Verma's guilt has to be proved according to processes known to law. And this in-house committee procedure is not adequate enough to prove criminal culpability beyond doubt for a very grave punishment to be visited upon a sitting judge of the High Court. That's the central point in the interview.
Then how will you react on a government move? Law Minister has indicated, and even Home Minister has indicated in monsoon session the government will start impeachment process. Despite knowing that there is a lacuna, there is a problem in entire scrutiny or entire investigation conducted by Supreme Court Inquiry Committee.
No, the problem here is that the recommendation by the Honorable Chief Justice of India, as it then was, has been made to the President. In which case now the government is left with no other opportunity either to reject the recommendation of the president, which never, the chief justice, which is never the case, or to act upon it. And since the offer of resignation was given by the then Chief Justice of India, Justice Khanna, to Justice Varma, which offer Justice Varma declined, now there is no other remedy or option available to the government than to act upon the recommendation of the Chief Justice of India. And therefore, as I said earlier, once the impeachment motion is taken up for consideration, knowing the politics of it, I have no doubt that the impeachment motion will be carried, and Justice Varma will then become the first judge to be impeached by Parliament, which will be a sad day for judiciary. I think in order to avoid this discomfiture and this ignominy, Justice Varma should consider seriously resigning from his post.
As former law minister, do you think government real intention is to dismantle collegium system?
If the government wants to change the system of judicial appointments, it can do so even without reference to this case. This case has given rise to a debate afresh about the appointments system. And I think that there is absolutely nothing wrong, in my considered view, if the present NJAC is enlarged to include a government nominee, as was suggested at the time of the UPA also. We had also suggested the National Judicial Appointments Commission to be enlarged by having the law minister and two eminent jurists on the committee. I don't see there is anything wrong in having a slightly different constitution of the committee that appoints the judges.
But do you think in today's circumstances, fractured politics, government can pass such bill without support of opposition?
The government will not bring in the bill until it is sure about the support. And I can assure you that the government will be able to muster the requisite majority to carry out the amendment to the Constitution.
There is two issues. One is appointment of judges. Second issue is accountability of judiciary. How do you see NGSC will deliver or fulfill both criteria?
So the judicial accountability was a different law that was in the making at that point of time. But as far as the Judicial Appointments Commission is concerned, the idea is to select the finest and the best judges. Now, as you know, the NJAC was struck down on the basis that letting the government have a say in the appointment of judges will amount to undermining the independence of the judiciary. I think it is a flawed argument. The independence of judiciary is a part of the basic structure of the Constitution and must be retained and protected at all costs. However, to suggest that if there is a government nominee on the committee, the judicial independence will be compromised is wrong. Please understand that before the judge's case, the first judge's case, earlier all judicial appointments were made exclusively by the Government of India. And nobody has ever blamed the judges then appointed to be less than independent or fair-minded. In fact, some of the best judges to the Supreme Court in the history of our country were appointed when only the government had the sole privilege of appointing the judges.
Okay. And I just want to know how long a chairman of Rajya Sabha can sit on notices given by opposition leader for impeachment of Justice Yadav?
Well, I don't think there is any time which is prescribed for him to take a decision, but it goes without saying that he has to decide it within a reasonable time. He cannot endlessly sit on the proposal. He will have to decide one way or the other. And I have no reason to doubt that by the time the next session, that is the monsoon session, is convened, some decision one way or the other will be taken.
Thank you so much, Dr. Kumar. Dr. Kumar has said it's a very sad situation, and Justice Varma has been not given proper hearing, and substantial fact has not emerged from inquiry. Now we will see how government will impeach in coming monsoon session.